The title of this presentation, this lecture is Confronting the Spectre of Divorce. Divorce is real. It's been there for some time. And every Congress, somebody files it. That's why I say I'm tired of going there because anyway, they don't want to listen. So I almost find it an exercise in futility going to the Senate or to Congress for hearings that they don't give you enough soundbite to explain your point, and it's futile. Hmm? For what I, it's futile for my part. No, I'm not saying that it's futile to fight that fight, but not for me anymore. It's not my level. Okay. Now, so what's the problem here? Let me remove this thing. It shows my calendar there. And what's this? All of these apps. How do I remove this? Mm-hmm. Mm, remove. Okay. Whoa. Yeah. So at the very first, I don't want to talk about divorce. To talk about divorce with you and to talk to you about the evil of divorce is like in Spanish they say vender miel al colmenero. No? It's like selling honey to the beekeeper. You don't sell honey to the beekeeper. Or in English, the equivalent of that, it's singing to the choir. No, you don't sing to the choir. The choir is singing to you already. You sing to the choir. It's an exercise in futility. So the real audience to talk to are our lawmakers. But as I said, not for me. A divorce bill has been filed in every Congress since the 1990s, and I have been called to speak at the committee level discussions in the Senate and in Congress several times since that time. But I think we of the pro-marriage and pro-life movements have been approaching this issue wrongly. Hmm? The reality that we need to face, and it's a reality, is the reality of irreparably broken marital unions, because there are such things. In other words, we have to ask ourselves, what is the motivation? What's the motive power behind those people who are advocating for divorce? Now, we have to assume that they have the best of intentions. So therefore, if they keep on doing what they're doing, it must be because there's something that they're fighting for. And there is. And that is to put a remedy to irreparably broken marital unions. Those situations where people think they feel that they're caught in a situation and they want out. Mm. Now, even the church acknowledges that some unions are not meant to be. I still remember good old Archbishop Cruz saying, "No, what God has put together, let no man put asunder." But he would add, "What God has not put together, let no man force together." Hence, even in church, there's what we call the process for the declaration of marriage nullity. Mm. And Pope Francis has even streamlined the process, removing the automatic second instance, because before, when you're given a favorable sentence granting nullity to your marriage, there's an official, after now is there, it's called the defender of the bond, whose duty it is to fight tooth and nail for the validity of that marriage that has just been declared null. So the law required him to elevate it to the second instance, to the appellate court. Well, Pope Francis has removed that requirement. Unless somebody wants to elevate it, somebody complains, then there is no norm anymore. There's no provision for automatic elevation to second to the appellate court. So therefore, in 15 days, if nobody elevates it, then it becomes executory, meaning to say that it's applicable. Hmm? The new tack is to fight, or to fight divorce rather, is to address the reality of irreparably broken unions. Not by legalizing the dissolution of marriage, that would be divorce, but by facilitating the determination and declaration of marriage nullity, which is a major cause of irreparably broken unions, despite all the pastoral efforts to mend them. In other words, is to think that if a marriage is, if there's a union, and despite what everybody thinks is the sacramentality of that marriage, all the pastoral help given to that couple, all the best of efforts that even perhaps even they themselves are applying, and still it breaks apart. Then you have to start thinking maybe there's no marriage to stand on. Hmm? You can't fix what's not even there. No wonder it's broken because it doesn't exist. Barring the other major cause, which would be that it exists, but somebody was unfaithful. In which case, granting divorce to somebody who's unfaithful is like letting a criminal get away with murder. You're rewarding the criminal by granting him divorce, especially if it's open to remarry. The most common cause of declaration of marriage nullity in civil courts and also on for divorce is what they call that psychological incapacity or just incapacity or whatever other reason. Now think about this: if you're thinking clearly, if somebody is incapable to have gotten into a valid marriage, why are you going to allow him to repeat the same mistake? Isn't that stupid? Hmm? And precisely that's what these people are trying to do. No, they're going to grant a person the permission or the ability to perpetuate his crime, so to speak, perpetuate to repeat what he had already gotten into. Hmm? How is marriage declared invalid? Civil law or law, both civil and canon law, has juridically configured the marriage institution, which is a natural one. I suppose in the previous class that you had or talk that you had, you were precisely exploring this reality that marriage is a natural institution. Yet even our constitution recognizes it calls marriage an institution. The problem is many people use words they don't even understand. You know? What do you mean to say when you say that something is an institution? An institution, instituere, is something permanent, or at least very difficultly changed. And if it's natural, because it's what it is, it's a natural institution, it's not even the product of human consensus, of legislation, for example. The nature of marriage is not determined by a law, by the raising of hands or by mutual agreement. The nature of marriage is determined by human nature. In much the same way that if you don't need to legislate that you should eat through your mouth and not through your nose because it's natural. It's a natural function. So if somebody insists on eating through his nose, it's not going to be illegal because there's no law against it, but he's going to get into trouble. Hmm? Because it's not natural to do things that way. Let's put this into a really gross application to sexual life. Sexual intercourse normally is done between a man and a woman vaginally. Hmm? Now, if somebody wants to do it some other way, anal sex, for example, pardon for me for being so direct, it's not going to work. Or if they want to do it between the same sexes, between two men, for example, that it has to be that way, that it's not going to work either. So that's what I mean by something natural, that nature itself establishes what it is. And what do we need to do? We just need to understand it and studying the reality of marriage, we have come up with its nature. And what's the nature of marriage? Is that union based on conjugal love. And what is conjugal love? It's that love that's a union between a man and a woman for the purpose of, and here you have the finality. mm, Pardon the review, but it's very important. You have to get this very, very clearly. Now, any institution, any act is defined by its finality. Hmm? That's what you call the final cause. That even in language, many times the final cause, the finality of a thing is expressed. That's why you call it higaan, because that's what it does. Upuan, kainan. You see, that's the end. That's the finality of that thing. Well, marriage is defined by its end. And what is its end? Number one, mutual help between the spouses. the mutual perfection. You don't get married to get something out of it. You get married to give something to the beloved. Love is like that. No? That's why I always correct people when they say that love is a give and take. No, love is a give and give. The only thing is, if it's mutual, then the other one will give also. But you don't take, you just receive because the other one is giving. That nuance is very important because if somebody fails, and that's the cause of friction many times in marriage, if you think that it's your right to receive from the other party, then if he fails, then it becomes troublesome. It becomes cause of conflict. But it's not supposed to be like that. Nobody has a right to take anything in marriage. You go into marriage to give, and the other party also gives. And in the process, you receive. So mutual help. And when the two sexes give and receive 100% to each other, then there's that possibility of the procreation of a new life. And that's the reason why same-sex union cannot be marriage because it doesn't have that possibility. Can there be union between people of the same sex? Of course, but don't call it marriage because marriage is that name is already answered for. It has a specific content in natural law, and that is the union between a man and a woman for this finality of mutual help and the procreation and upbringing of children. And because of this, you see how fast I'm going. Pardon me, but it's like that because my mind is working fast already. And my mother always tells me, "You speak too fast. You speak too fast," because my mind is going faster. And if I don't speak fast, then I won't be able to catch up with it. Well, okay. So going to this, back to this, no, that um, if that is the end of marriage, what again? Mutual help for mutual perfection, and then the procreation and bringing of children. If those are the ends that define the institution, then there's such a thing as the natural qualities that will make those ends accessible. And what are these natural qualities? You know that very well. Monogamy and indissolubility. There can be really no pursuit of the mutual help and mutual perfection of the parties like that starlet that I once heard in a noontime show. Hmm? She was asked, "What's your provenance?" At first, she didn't even understand what provenance means. No, hindi ibig sabihin probinsya. But word, what is your racial provenance? And then she said, "I'm half German, half American, and half Filipino." So you're three halves already. So you cannot have 100% to someone and then another percent to somebody else. Conjugal love is exhausted in the partner. That's why Nat King Cole was right. Hmm? If I give my heart, it will be completely, or I'll never give my heart. If I fall in love, it will be forever, or I'll never fall in love. So that's the thing. In the moment that you think that, you feel that, rather, you feel that way too, then I'll fall in love. I'll give my heart to you. That's what conjugal love is. And marriage is nothing but the institutional expression of that fundamental reality of human nature, which is conjugal love. It's an institutional expression of that. That institutionally, human beings have expressed conjugal love in society in that institution, which is called marriage. Okay. Now, that's the reality. Now, what does the law do? I don't know how many of you are lawyers out there, but there's such a thing as the ontological truth, the reality in itself, and its representation in what I normally tell my students in law as the juridic matrix. You remember the film Matrix? You remember what that film was all about? That they were using human beings as a source of energy, the so-called fuel cell, which they're still trying to perfect. That's real. There's such a thing as a fuel cell. The fuel cell is more efficient than a chemical cell, not as efficient as nuclear fission, but definitely much, much more efficient than the breakdown of chemicals like in an internal combustion engine. or even in a dry cell battery. When they perfect the fuel cell, a little cell like that, like your little cells that you put in your cameras, will be enough to run your car for a whole lifetime. That's how efficient fuel cells are. That's how efficient the human body is. Why do you think you can't lose weight just by exercising? Hmm? Because just one banana is enough to fuel a 5 kilometer run. Can you imagine? Because that's how efficient the cells are. But anyway, in that film, Matrix, they were making use of human beings as fuel sources. But then how do you do that? No? How can you keep a person, shall we say, docile to such a process that they're just plugged into this great thing and their energy is being drawn from them? Well, precisely by feeding, that's fiction, right? By feeding a virtual reality into their consciousness, such that they're happy, and if you want them to to give more energy, you put there a scenario where they're running, and if you don't need that much energy, you make that reality, that virtual reality, that they're sleeping. So that was the argument of Matrix. Now, here's the thing: in life, there's a juridic world which is just like a matrix. You look at yourself, no? Of course, you exist. You're there. You're a natural person, but you have a representation in the juridic world, without which you don't exist. And how are you represented in the juridic world? Well, you have to have a birth certificate, that you have a residence, and then you go through school. Later on, you will be working, you will enter into contracts, you have a citizenship. All of those things are like situations and relations defined by the juridic matrix that makes you real, without which you are erased. That's another film, no? Erased, where you are erased. You're not really erased, you're still there, but you don't have any juridic framework or footprint anymore. You don't have any record, you don't have any bank records, you don't have any social media presence. So you don't exist virtually, but you do exist. Now, marriage has been represented in the juridic world also, such that its existence can be verified because of all of those things there. Now, what happens in the declaration of nullity is it is shown that one of those elements is not there. And so, therefore, it is declared that there was no marriage. The marriage is declared null. I remember once I was in a doctoral thesis defense, and a former dean of maybe is the top law school in this country, said something, no, referring to the declaration of nullity that we have both in church and in civil law in the family code, referred to it as a fiction, because he was trying to argue precisely, why don't we just allow divorce? Why go through this legal fiction, which is a declaration of nullity? And I was about to speak up out of turn, because it was a thesis defense and I was not supposed to speak up, but I couldn't contain myself, because precisely my mind immediately reacted and I didn't know that my microphone was on. I was here from this speaking. It was a Zoom meeting, and he cut me short. And of course, I kept my peace, because he was right. But then I was just thinking to myself, you see, he called the declaration of nullity a legal fiction. And what I wanted to say was precisely it's the other way around. The legal fiction is the marriage that has been formalized, solemnized. Everybody thinks you're married, but actually that's the fiction, because there was a defect in the coming about of that marriage. And a declaration of nullity is nothing but the effort of the court, the tribunal, to repair that damage, to correct that fiction, to declare that it was a fiction. There was no marriage pala. Hmm? Right? Imagine if two people got married, everybody celebrated it, very happy, etc. And then their marriage night, what happens is something that happened to that Laude person that was killed by that American serviceman, because it turns out that one of them is a transgender. So what? Do they need to get a divorce? No, what they need is a declaration of nullity. It was null because one of them, both of them are male. No? So it was a fiction. That's what happens in the declaration of nullity. Therefore, it can be declared null. Of course, this needs an authoritative declaration, not just an opinion of one of the parties. In this case, there is nothing to annul. There is a declaration of nullity. You see, you don't annul a valid marriage. If you annul a valid marriage, then that's divorce. What you do is you declare that it was not valid. So there's nothing to annul. You have to get this nuance very clearly and defend it. Now, we go to the juridic structure of marriage. The juridic structure of marriage, how marriage, that institution, conjugal love, is represented in law by three, shall we say, pillars. There are three juridically verifiable realities that bring about marriage, that constitute marriage: capacity, consent, and form. What is capacity? Capacity, to put it very simply, is the capability of a person to contract a valid marriage. Now, in canon law, this is very well studied. That's the problem, no? Canon law has been studying this since the 12th century, and civil law has been studying it since this century. And so they would do well to look at what canon law has done about it, because canon lawyers are not exactly stupid. No? So therefore, the thing is, okay, they got enough of it. That's the reason why the caput nullitatis, the causes for the declaration of nullity in the family code of the Philippines were borrowed from canon law, but it was borrowed very imperfectly. It's like I don't know. It's like we borrowing the biryana of Hindu or Indian cuisine, diba? You know, biryana, if you know Indian cuisine, but then not quite, and it became birenghe instead. For those of you who are from Pampanga, now you know what birenghe is. Or some people think that birenghe is the Philippine adaptation of the paella of the Spaniards. No, not quite. No, it's quite different. So this is the same thing that happened here. They borrowed, but they borrowed so imperfectly that it's very imperfect, as I will show you after a while. So capacity is simply a statement, or canon law simply states that a natural person is capable of getting married. Why? Can you argue that? Because marriage is a natural institution. Adam and Eve were made that way, man and woman. That's why, for those of us who are believers, we have an additional input, which is Revelation, that says in what, in Genesis chapter 1, remember, in chapter 2 rather, it says that for this reason a man shall leave mother and father and shall cleave to his wife, and the two shall be one flesh. In other words, it's natural for men and women to get married, so they're naturally up to it. Unless, and here's the thing, there are incapacitating qualities or circumstances. And canon law has defined 12 of those, and they're called impediments. 12 situations that render a person incapable of validly getting married. One of them is age, for example. That there's a minimum age necessary to validly get married, or the existence of a previous marriage that creates an obstacle to a valid marriage, or consanguinity up to a certain point that also creates an incapacitating quality or circumstance or situation, etc., etc. There are 12 of those. Then, oops, I've said that already. And then there's consent. Consent given at the particular moment of the marriage celebration. Consent is the most important element of marriage. Matrimonium, or rather consensus fit matrimonium. Consent makes marriage. No power on earth can substitute for the consent. Without consent, there can be no marriage. And therefore, canon law, the juridic world, has defined hinimay na talaga, no? What goes into a consent? Or vice versa, what invalidates consent? Himay na himay yun. Right now, for example, I just show you how these things go, no? Here, can you see this? It's a case that I just received this morning for marriage nullity between two people, okay? And then there, you see that's the first page, and you see that their picture. Okay, so we don't go, it's just a thing. And what is the ground that's being alleged here? The ground being alleged there is lack of due discretion. So in other words, they got married without thinking very well about it. So if you didn't think very well about that marriage, lack of due discretion, lack of due deliberation, for many reasons. That's why I said hinimay na. There are several factors that can get into it. Then you can say that the consent was not valid. The minute you can say afterwards, no, what were you thinking? Well, precisely, he or she wasn't thinking, or at least not thinking properly. And if that can be proven to a court, then the court will declare that that marriage was invalid. Hmm? So Mark is thinking there. Maybe his marriage was not valid. I'm sorry. You had such an expression of thinking. Is this applicable to me? Okay, don't out-analyze your own marriage. It's not good. I'm just joking. You see? That's what you call a comic relief because we were getting too serious. Next, here you are. Canon 1057. Marriage is brought about through the consent of the parties, legitimately manifested between persons who are capable, according to law, of giving consent. No power can replace this consent. So matrimonial consent is an act of the will by which a man and a woman, through an irrevocable covenant, mutually give and accept each other in order to establish marriage. That's what is expressed in the so-called marriage vows that are there in church. No, the content of which it's very important. When you consent to something, the way you're doing something, you're consenting. You have to define what are you consenting to. Hmm? You are consenting to establishing the marriage bond. And what is that? That's defined. You cannot change the content of that. It's not a business partnership. It's not an athletic camaraderie, or it's the one that was defined before. No, mutual help for the procreation and upbringing of children that therefore has to be monogamous and for life. And as if that were not enough, in church, that's actually stated. The priest will ask you, do you take Marites, do you take Darwin here to be your lawful wedded husband? And you said, I do. And then, Darwin, do you take Marites here? Here present, this Marites, not any other Marites out there, but this one as your lawfully wedded wife. And then, hindi pa nagkasa yun, he's supposed to spell it out. What does that mean? To love and to cherish, to love and to hold, for richer, for poorer, in sickness and in health, for better or for worse. Many women forget about the for worse part. There can be a for worse, no? Tataba yan, pwedeng mambabae yan, pwedeng maging sugarol yan, pwedeng maging get into drug addiction later. Now, it's a different story. From the very beginning, a drug addict na, no? You didn't know that. That's an impediment. A drug addict cannot validly get married, etc. Pero if he became that in the future, you're committing yourself to love and to hold, to cherish till death do you part. Yeah? You have to be very clear about that. That's what marriage is. Ay, hindi ko yata kaya yun. How can I commit myself to things of the future? Kaya nga tinawag na commitment eh. If it's things of the present, that's not commitment. No, that's there already. No, that's a dog with this contract, compraventa. No, you're buying something. No, you're committing yourself to this person. in a bond that will last for a lifetime. Can you do that? Of course you can, because you're free. And what if I think differently tomorrow? Well, you're not supposed to, because you're committing yourself precisely not to think differently tomorrow, but to think this way until death. You see? That's what that means. And then the last thing is form. That's purely external. What are the formalities that go into marriage? No? Now, what are the causes of juridic nullity? So let's admit him there in admit now. Causes of juridic nullity. There's no annulment in the Catholic Church. We said that already. But what we have is a declaration of nullity, wherein the ecclesiastical authority, always through a judicial process, never just an administrative one, declares that a given marriage, either to presume valid, was in fact invalid from the start due to a defect in any of the three factors that juridically structure marriage. Meaning to say that there's incapacity to contract due to an impediment or an incapacity to assume. Second, that there was a defective consent for all the reasons that we cannot get into now that makes the consent effective. And there was lack of canonical form. It was not expressed properly, in which case it can be declared null. Now, whoa, himayin pa natin, matrimonial capacity. What are the canonical impediments to contract marriage? We will go through this very, very quickly. In brief, what they are qualities, situations, even relations that impede the accomplishment of the institutional ends of marriage. We already said, diba, that marriage is for mutual help and for the creation of upbringing of children. Now, there are certain conditions of the person that will make those things impossible. So, therefore, if you have any one of those conditions, it impedes you from getting married validly. You know? And again, as I said, canon law has been at this since the 12th century. So therefore, himay na, they have identified 12 of those. What are those 12? Ugliness. No, hindi kasama yun. You can be ugly if you're still capable of getting married. Summary. Impediments affect the person, rendering him or her incapable of contracting marriage validly. All impediments are subject to documentary proof and can therefore be expedited in a purely documentary process. Now, since they are legal impediments, they're established by law, they can be relaxed by the competent authority, and that's what you call dispensation, except those that are considered as part of the divine law, like, for example, age. Nobody can relax the requirement of age. I mean, if you're only 12 years old or 15 years old, you cannot validly get married. Or impotence. Yeah, impotence is an incapacitating quality. Why? Because it's at the very heart of conjugal love that they should be able to have sex, because that's the bodily expression of conjugal love. So if somebody cannot go through sexual intercourse, that impedes him from validly getting married, him or her. Consanguinity up to the second degree of the collateral line, meaning to say siblings. So the law has defined that siblings cannot get married validly. And there are reasons for that, which I'm not going to go into now. And then finally, there's a 13th impediment, which is psychological incapacity to assume the essential obligations of marriage, which unfortunately is the one that has been imported by civil law, under which all processes are being tried, as if it's the only ground for nullity. Now let's go to matrimonial consent. What is the juridic structure of matrimonial consent? How is this phenomenon of willfully getting into the marriage union, which is an expression of conjugal love, how is this? First of all, we have to ask ourselves, what is matrimonial consent? Marriage is brought about through the consent of the parties legitimately manifested between persons who are capable, according to law, of giving consent. and no human power can replace this consent. It is a sine qua non condition. So after having said that, then canon law dissects, refines all the elements that go into consent and vice versa. Therefore, the factors that can invalidate that consent. Even if somebody says, I do, but if there's fear or there's confusion or there's tension, that all of those things invalidate that I do. Hmm? So it must be deliberate. The will implies an act of the intellect, inisip, conjugal, meaning to say a man with a woman or a woman with a man, inisip, magpakasal, and irrevocable. A specific contract, or it's a special contract, intrinsically irrevocable, because the object of the contract is a human person, and human beings cannot be borrowed or bought. They can only be given. And when you give, you cannot take back what you have given. What do you call it when you give and you take it back? That's what you call an Indian giver. uh, Indian. Because when you give something, it's not yours anymore. You gave it already. So you cannot take it back. And that's what happens in marriage. You give yourself, so you cannot take it back. If you take it back, that's robbery. Mm. Many elements enter that process of the intellect. And roughly, we can say very quickly the knowledge of marriage in general, its nature, its ends, its essential characteristics. Precisely because of this, that there's a requirement of age. Because below a certain age, you can't expect a person to know all this. Even after a certain age, there's still so many people. There's one of my favorite peeps. In this country of ours, somehow women develop all of these things early. So 18 years is just about right. Any woman knows at 18 what getting married is. But most guys at 18, they don't know what it is. Hmm? They're still playing video games and things like that. Hmm? Uh, that's why if I were one of the things I've been advocating for, if you really want to make marriage works and not have to think about divorce, is make sure that people are getting married properly with all the formation necessary and increase the minimum age for men. I'm okay with 18 for women, but for men, I'd put it at 24 or 25 even. No, any guy younger than that is trouble. Implications of marrying or knowledge of the prospective spouse. Again, there must be enough courtship in between. Oh, then the implications of marrying that particular person, the aptness of that person to one's ideal of the person with whom to form a permanent consortium of love and life. The so-called, what do you call them? Whirlwind marriage, no? Or a whirlwind courtship. Yeah, whirlwind courtship, also a whirlwind marriage and a whirlwind breakup. So everything is a whirlwind. Dumating parang ipo-ipo, naglaho parang ipo-ipo. So it's like that, no? I don't know why people are in such a hurry, no? There are certain things that you cannot hurry. No? I don't know. Just today, I was commenting over table that the art of sautéing is fast disappearing. Most women don't know how to saute anymore. I mean, I see somebody there who's a mom, and please teach your daughters how to saute properly. No? That you have to get the Maillard reaction with the proteins, otherwise the flavors don't come out. And what you have instead of sauteed, it's poached. No, many times you see the sahog, it's poached. It's not sauteed. Hmm? And there's a guy there again. Mark is saying, what is he talking about? I happen to be a culinary expert, and I'm very particular about this. When I see sahog that's poached and not golden or brown, so well, it wasn't sauteed properly. Anyway, there's certain things you can't hurry, and courtship is one of those. You can't hurry through courtship. Hmm? And then finally, the opportunity of marrying that person there and then. When I what I mean by opportunity, I mean is opportuneness. No? Tama ba? Napapanahon ba? Because you could be the right person for each other, but you're only 19 years old. So mali, hintayin mo. So wait until you're 24, 25, 26, and then since you're really meant for each other, you'll marry each other. But with the proper characteristics, or qualities. Now, here we go deeper. And I'm sorry for doing this because there's nothing like understanding this to understand why we don't need divorce. Hmm? And vice versa. Until those legislators understand this, then they will keep on harping on divorce because they will look at it as the solution to what you call this problematic unions. When what they should realize is that those problematic unions suffer from any one of these things. So you don't need divorce. What you need is to declare that they were null, that they were invalid from the very beginning. That's what has to be done. Um, but why is that not being done? Because the law, the family code, is severely flawed, such that it makes the declaration of nullity because of the most common reason, which is the lack of due discretion, impossible. Why? Because lack of due discretion is not one of the grounds in the family code for the declaration of nullity. So, if the most common cause of nullity is not one of the grounds recognized by law, then you cannot get a declaration of nullity. And since you can't get it, so better na lang get divorced. Wrong solution to the wrong problem. It's just like the headline I saw the other day. After this hazing problem, this deaths in Adamson, and it was clearly that they were fighting against the reinstitution of ROTC. What's that to do with it? No, Gano'n, 'no? Paano ba kayo mag-isip, no? You have to identify the problem. The problem are hazing in fraternities. So take away fraternities. Don't take away ROTC or the prospect of bringing ROTC, di ba? But people don't think properly. Anyway, so let's go back to this. So what are the factors that affect either or both the intellect and the will? So factors affecting the intellect. So internal is the use of reason. And that's where immaturity comes in, or psychological anomalies, emotions, error. So that affect the intellect internally. Nagkamali tuloy ng isip, no? Because of fear, because of tension, because of shotgun, because of an impending, what you call this, examination. You know, I have had more than two cases already of people who got married in the interim between internship and residency. They're doctors, in other words. When they're there, their mind is in how can I get into residency? But then here's this girlfriend. We've been girlfriend ever since medical school. So this is the best time to get married in this in between. But hey, nag-iisip ka ba ng matino at that time? Normally, the cases I've been through, um, it's just the girl who went through the preparation because the guy is thinking of some other thing, umuo lang ng umuo with arrangements, etc. Then afterwards, trouble because they were not thinking properly. So those are internal. But there are also external factors, fraud, simulation, for example. No? Anything that will lead a person to think one way when actually that's not the real thing. Fraud or simulation. Kala ko mayaman ka, hindi ka pala mayaman. Kala ko virgin ka, hindi ka pala virgin. Or things like those, that you lead a person to, or fear. If there's fear, even if it's not done on purpose, but if it's causing fear, it's subjectively, it causes the person not to think properly. Hindi naman kita tinatakot, I'm not threatening you. Sabi ng tatay, kasi yung tatay may dala shotgun, no? I'm going hunting. So, I didn't bring this to scare you. But he got scared. So that's a ground for nullity. So those are external factors. And then there are factors affecting the will, internal fear or external violence. So behind the marriage nullity cause due to invalid consent is either of two reasons. a lack of true judgment or decision to get married. Thus, the act of the will to marry would have been made contrary to or without the true judgment, but rather moved by fear or violence. That's what I call a lost judgment or faulty judgment or decision to get married due to ignorance, error, lack of deliberation. And that's what I call an imperfect judgment. In both cases, the consent is invalid. Now, finally, let's just go to one provision here, Canon 1095, which is famous. That the following, according to this, are incapable of contracting marriage because they're incapable of giving a valid consent. Number one, those who lack sufficient use of reason. Now, you can lack sufficient use of reason habitually because you're low IQ or you're abnormal, or temporarily under the influence of drugs or influence of drink. No, so second, those who suffer from a grave lack of discretionary judgment. So the first one is the lack of the use of reason. This one is a grave lack of discretionary judgment. Mahinang mag-isip. Hindi dahil hindi nakakapag-isip, kung hindi, medyo magulo mag-isip. No? There are people who are like that. Especially concerning the essential matrimonial rights and obligations to be mutually given and accepted. And then finally, third, those who, because of causes of a psychological nature, are unable to assume the essential obligations of marriage. This is what is known as psychological incapacity, which is the only thing that has been imported by the civil law. So number one and two are not there, especially number two. And it just so happens that number two is the most common cause of nullity, no? Lack of true discretion, lack of deliberation, lack of good thinking. It's not there because the law, the civil law assumes that if you say yes, the presumption is inisip mo. But what kind of presumption is that? No, di sana magaling na lahat. How come there's so many laws and ordinances which are, you think about it, it's kind of stupid, no? My favorite example of this is the elevated U-turn in there in Taguig or in put up by Marikina. You remember the elevated U-turn? Ano kalaki pa nung sign dati doon, no? It's the first in the world. Nowhere in the world have they done this. It didn't even occur to them that, hello, if they didn't do that, there must be something wrong with that solution. No, and so it's laughing at everyone there. So expensive, it didn't solve the problem. Why? Because so not everybody, it's not automatic that people think clearly. So that has to be safeguarded. So finally, those who, because of causes of psychological nature, what that means is there are some people who suffer a psychological condition that renders them incapable of, shall we say, delivering on their commitments. If you cannot deliver on your commitments, then you cannot validly make those commitments. That's the logic. For example, if I tell you that if you all finish this lecture, tomorrow I'll treat you to a free ride in my submarine or in my yacht, no? Okay, we can get all kinds of notary publics to witness that commitment of mine, but that commitment will be invalid. Why? Because I don't have a yacht and I don't have the capacity to take you on a ride on a yacht. So therefore, that's a that's a called that's invalid. Okay, finally, let's move forward. Now, all of this point to one thing. The driving force for a divorce law is the desire to dissolve irreparably broken marriages. Now, by recognizing that there is no marriage to be broken, then the driving force for the divorce law will disappear. If we help them realize that what they're trying to do, which is to break a marriage which is irreparably broken, is inutile because there's no marriage that they need to break. What they need to prove, rather, is that that marriage was invalid from the very beginning. Then they won't need a divorce law. Without having to resort to a divorce law that affects not only non-marriages, but all marriages. Because an invalid marriage is a non-marriage. By instituting a divorce law, it won't only affect the non-marriages, it will affect all marriages. Because a divorce law will change the meaning of marriage from a covenant, which is indissoluble. Now marriage will be defined as something soluble. Okay? You change the content. It's like your seafood kare-kare. No? I always dislike it when I see seafood kare-kare. Pwede ba? You give it another name, no? Because kare-kare is well defined. It's a very, if not, I think it's the best recipe that we have come up in the Philippines, no? The most sophisticated recipe we have is kare-kare. And now you're going to make it seafood. Well, you use another name. Ang dami-dami naman pangalan, no? The same thing with marriage. No? If you want something that can be dissolved, then fine, but don't call it marriage. So crazy is this fact that, for example, in the US, where they have instituted divorce, now they're going a full circle that there are some states that now have marriages, but you have to stipulate it though, that I want to get married, but in a non-divorceable kind. Para mong sinabing, you have coffee, and then you have decaffeinated coffee, and then you have caffeinated, decaffeinated coffee. That's why it's caffeinated. Eh, sira ulo mo. Basta coffee, no? Coffee is really caffeinated. Marriage is really indissoluble. So if you want a non-dissoluble marriage, well, that's what marriage is. What you have to do is take away divorce from the equation. Diba? So I think I have used up my time. I'm open for questions, question and answer before I put you all to sleep.
And thank you very much, Father. And